Hello, viewers, and thanks for tuning into WACA TV's new business series, True Business Ownership with Rita Coco. I'm Rita, and I'm your host of these series. In every episode, which happens once a month, I bring to you best practices that help small business owners do a couple of things. One is to significantly grow your business, and two, to do that growth without the suffering, the sacrifice, and the stress, which you know I'm talking about, that probably you experienced just to get where you are today. And every month I bring on an expert who will work with us and talk to us about how to implement those best practices in their field and in their industry. So today we are going to have a topic, and here it is: adapting to the new legal landscape for employees in Massachusetts. So if you have employees, stay tuned. Do not touch that remote just because you think, my employees, they're great. Why? I wouldn't have any hassle with them whatsoever. Oh, and they've been with me forever. Famous last words, right? So keep in tune to us, because at this moment, you're going to meet someone who's really great at giving us the lowdown at 4 to 5 different laws that are happening in our small business area. So my guest today is Allan MacLean. He's a seasoned attorney with MacLean Employment Law, PC, and he'll talk today about the new landscape of legal areas for us to know how to move our way into these laws and without having them affect us. Hello, Allan, and welcome.
Hi, Rita. Thanks for having me.
Oh, I can't wait for our viewers to hear you. You're just so good at keeping things clear, precise, and to the point. But before I give that mic over to you, Allan, viewers, I'd like to give you some background about Allan, because although he's been in the business for a very long time and has loads and loads of experience in this window, we want to talk about the expertise he has regarding how he can help to mitigate some of these laws. So Allan graduated with law school, and in the next year he was clerking for judges in the Massachusetts Supreme Court. So he knows his way around a bit, shall we say, in the court, a lot of way around. And he's been in business as a employment law for over 15 years. So what does he do for his clients? A lot of things. First, he does for his clients what he's doing for us today. So thank you, Allan, is that he is giving his clients not only what has passed in laws, but to be proactively saying, this is what's coming down the pike. So that's one of the major things. He puts policies and procedures into his clients' organizations so that they're ready to mitigate that landscape. 2 or 3, he does wages and hour conversations a lot. He also talks a lot about accommodating the employees and what's inside of accommodating and what is kind of outside of the accommodating, and especially when it comes to leave of absences, which is huge for us. If you're a small business, pay attention to that part. And he talks a lot about preparing and enforcing non-compete agreements. Someone leaves, are they taking our clients? Are they going to open across the street? Oh, so beware, there's lots of advice. And then in conclusion, there's a what I would call a context: hiring, discipline, termination, layoffs. He does all of that for his clients. So now that you know a little bit about Allan, let's start, Allan, with what I think you're going to talk about, which is the entire landscape of the laws that are new. And you're going to start with, oh my goodness, paying employees on time, right?
Yeah, that's right, Rita. So this is a very timely topic. And again, thanks for having me. So happy to be here. And it's something, this new change in the law related to payment of wages is something that all employers need to be aware of. So it relates, as I said, to the obligation to pay employees. And this law imposes really harsh consequences. And it's really important that employers pay attention at the time of separation. That's the time when employers really get tripped up on this new change in the law and the existing law as it is.
And so when you say get tripped up, what do you mean by that, get tripped up?
Sure. Well, they end up violating the law is what happens. And so they may be acting in good faith, trying to do everything right, but they make a mistake and they don't pay the employee on time, or they don't understand that they need to pay the employee the full extent of the wages owed. And that's where I see employers get tripped up.
Oh, wow. So I'm all ears. Let's talk a bit about this. How are you going to approach this with us?
Yeah, so what I'd actually like to do is start with a little bit of a story. And I think this is going to sound familiar to a lot of your viewers. So let's say you're an owner, own a small business, right? And let's call this owner Sheila. And she sells a special type of flooring. Say it's self-cleaning flooring, magic floors.
Okay.
One Sunday evening, Sheila's reviewing records and realizes that one of her employees may be taking some materials from her. She's looking at records, sees some materials missing, does a little digging. She suspects this employee is taking materials, maybe doing some side jobs on his own.
Ooh.
So we'll call the salesperson John.
Okay.
And so Monday she confronts John. He confesses. He's, oh, sorry, I've been, tells her the whole story, the whole spiel. He's been doing this. He's been taking side materials, getting paid on the side. And he also has a sob story that goes with it. And unfortunately, things are tough at home. He can't pay his kids' tuition. And this is what has led him to go down this path. And so Sheila has to think it over. And notwithstanding John's situation, which she's sympathetic to, decides she's going to have to let him go.
Oh.
But
Makes sense.
sure, in consideration of his circumstances, though, she says, you know what, I'm going to give him $1,000, help with his kid's tuition on the way out the door. She's going to treat his separation as a layoff. Very nice of her. So
wow.
She lets the employee go, tells him about the $1,000, gives him $1,000, tells him she's going to treat it as a layoff, lets him know he'll get his final pay in a few days on Friday with the regular payroll.
Wow. Okay.
So sounds pretty good. Unfortunately, this business owner's in some trouble. Sheila's gotten herself in some trouble here. She's inadvertently gotten tripped up, as we were saying.
Oh my goodness gracious! Wait. Go. First of all, she gives him $1,000 out of the goodness of her heart. Then she gives John the opportunity to collect unemployment and gives him the layoff title versus a firing title. And then he's not getting, he's getting the full pay. She's not saying, well, I'm going to take some off. So he's getting the full pay. And then he's getting, I think he has probably some used vacation, right? He probably has that. And he's probably getting that, and she is in trouble. Okay. This is where you have to tell us what is going on here.
Yeah, so Sheila's a good actor here in the general sense that we think of it, but the law is very specific in Massachusetts, in particular, regarding payment of wages. And so typically you have to pay your employee wages on time, right? Let's understand the law first. And so that for an hourly employee, that's usually weekly or biweekly, and in my experience, almost all employers universally try to do that and do that. As you mentioned, wages include vacation time, so unused but accrued vacation time. And then this is another critical component here. When an employee separates involuntarily, like John was involuntarily let go here, the employer has to pay all of the earned wages that same day, including vacation.
Okay, so although Sheila's being really kind, because John didn't walk out the door, she said, John, you walk out the door, and she said it, but didn't have his money right then. She's violating a law. Wow.
That's right. She didn't pay him that same day.
Yeah,
and so even though the terminations looks like it's just here, it's involuntary. So she had to pay him all that, should have had the check prepared ahead of time.
Okay, so I'm Sheila. I'm looking at my books on the weekend, Alan, and I'm like, okay, I'm too scared to have this John, although a great guy, didn't know this, scared on keeping him. So I can sort of get him to leave, but I can also say, and I will terminate you. So we kind of get him out of the office, so he's not next to any material. And then I can tell him I can pay him that the actual day that he gets done is the day that I'll pay him. So
Yeah, I think you're right on target. Yeah, I think you're right on target here. What Sheila should do is she should suspend John, work everything out, get the check ready, and then pay him inclusive of the vacation time. Now, one thing that Sheila really needs to be aware of is the harsh penalties under the Wage Act. If she doesn't pay him the wages due, she's going to owe triple the amount due. And so if she owed John 10,000, now she owes him 30,000 plus his attorney's fees. So this can be, a really surprising, harsh consequence for employers. And, in the new change in the law, let me get to that, because this has kind of always been the way it's been. But the new change in the law is that previously, if an employer made the mistake and didn't pay someone on the day they were due to be paid, they could clean that up, right? And then the employer wouldn't be stuck with the triple wages, so long as they paid before a court action was filed, right? That's how employers understood this. So, there's a little bit of a mulligan opportunity there. That's no longer the case. The Massachusetts Supreme Court has said, nope, if you miss the date, you owe the triple amount, period. Doesn't matter if a court action is filed at all. So now employers really need to be extra cautious.
Boy, I'll say extra cautious, because that's an awful lot of monies that she has to take out of pocket, and she's being so generous. And so does $1,000 that she said to John, does that kind of like pay? Can it be like 10,000 minus?
No. So unfortunately, no, that's just a gift that she's given him. So she doesn't get any credit for that. Now, she could have considered paying that or giving him that payment in exchange for a release of claims, which is something I often work with employers on. It's a common practice. You give them a payment, usually it's at the time of separation, and in exchange, they give you, at least sign a document basically saying that, okay, I won't sue you and bring any claims against you. And this is great because it gives employers peace of mind and closure in what can be a difficult circumstance.
So when do you kind of talk about that? Because John's walking out the door, and that $1,000 I'm going to pay you, John. But John's already angry in a way. Hey, I'm leaving. I might still want to. So when do you start talking about that 1,000 that I'm going to, when you separate, should that happen?
Yeah, I mean, there's no set time necessarily, but typically at the time of separation would be to raise it. Because if an employer is going to file a claim, they're probably going to do it fairly quickly. And so raise it then and get all the paperwork situated and get the closure, like we said, that would be really helpful for you as a business owner to move on. Right. And move on.
Okay. And I know we need to move on, and we can keep on talking and talking because you do have so many laws that we have to cover. So folks out there, you need Alan. He'll have his information at the end of this program, especially if you are in that situation, or if it's even on a radar. So thank you, Alan, for that. I know we're into our next topic, I bet, in law.
Yeah, no, yeah, so exactly. And this is another timely topic, actually. And so we've all been affected by the pandemic, right? And business owners in particular have faced unique challenges. And there's been a lot of changes in the workplace. A lot of people are working remotely, right?
Yeah, that's true.
Employers need to be aware about how this impacts them from a legal perspective. So going back to Sheila, let's say pre-2020, she was operating, her administrative employees were in the office. She was able to oversee them personally. Things were going smoothly. Probably didn't get many remote work requests. If she did, it was not the norm anyway. Now we're in 2022 though, and like everyone else, Sheila had to adapt, like every business owner, right? She had to survive. And so a lot of her office employees were likely working remotely. And they've been doing that for the past couple of years. And so some of them don't want to come back to the office, Rita. You may have heard about this. And so what should she do, right? How does she manage this? And there are some legal considerations to keep in mind here.
Yeah, let's talk about those legal considerations, Alan, because in the beginning, in March of 2022, there was a lot of folks out there who, people just disappeared. And then there was a lot of courses that I know I had to teach about how do you manage remotely. So this remote stuff you think is done, but it isn't.
No,
So tell us about those, the legal ramifications or what this covers.
yeah, sure. So number one, employers need to be consistent in who they permit to work remotely. A danger area they can fall into, a trap, say, is that if they start treating people differently,
Oh, yeah.
that could open them up to claims of discrimination, right?
Oh.
One example that comes to mind is, are you assuming that, say, a female employee is going to have caregiving responsibilities that are going to take them away from work if they work remotely, but not your male employees? That could be considered discrimination. So you want to be careful there. There are other ways that could happen. Another thing to keep in mind is if employees are working remotely, you want to make sure they're reporting all of their time worked. And so you want policies in place and practices, making sure that they're responsible for reporting all their time and that you're paying them. Another policy you're probably going to want is confidentiality. You could be out at a cafe somewhere with your confidential information, leaving it on a table or what have you. That could be problematic for employers. And then you're going to want to know where employees are located. Maybe you have an employee that lives in New Hampshire, worked in Massachusetts. Does New Hampshire law apply now? Should you be taking New Hampshire payroll taxes out? So you just want to know where they're working so you know what to do and how to treat them accordingly.
So does it matter why my employee wants to work remotely, the why factor?
Yeah, absolutely. So if a request is made to work remotely based on a disability, then you're going to really have to give that individualized attention and make an assessment whether you can provide a reasonable accommodation. That's what the law is going to require you to do. And so, these requests could come in for mental health issues, maybe that's anxiety in being in the workplace. A lot of people have anxiety now, particularly with the virus, et cetera. Maybe there's mobility issues, there's any number of types of disabilities that could come into play here, but you need to individually assess them. So prior to the pandemic, there were lots of reasons why employers could say, unfortunately, we can't accommodate you. Maybe they couldn't supervise, they didn't have the right equipment to have someone work remotely. Maybe there's some confidentiality concerns, but that analysis has changed dramatically. We've all had to adapt. Everybody's been working remotely for a couple of years. And so employers had to get equipment and find out new ways to make this work. And so the legal arguments that this is an undue hardship, which is sort of one of the buzzwords from a legal perspective, or the employee can't do the essential responsibilities of the position, those are going to be much tougher to make today, successfully anyway. And so, Sheila can supervise an employee by Zoom. Employees can communicate by email, text. They can get on Zoom calls with clients. They can access records via VPN. There's just so many programs and software products out there that are available to allow employers to make these reasonable accommodations.
Wow. So I work in trades. I work a lot with trades folks, and they were essentials at the time. So my mind says, how do you become remote? So I have people in the office, I have people out in the field, I'm in the trade. So, and I know I could be discriminated, but is there anything about positions here and what to expect based on the kind of positions I have and what the law says?
Oh, yeah, absolutely. You're right on there, Rita. So for office workers, a lot of that analysis I just went through applies, right? They can probably do most of their work remotely, bookkeepers and that sort of thing. But for, take Sheila again, the people, her employees putting down the flooring, they can't do that remotely. Similarly, maybe someone working at a construction site. those positions can't be done remotely. So you are going to have to look at the type of positions, but many office workers, remote work likely can be accommodated in those circumstances now.
See, this is what I love, is the fact that you have married the word accommodating to remote. So when someone says, geez, I really don't like that commute anymore. Am I accommodating you because you kind of don't like to drive anymore? Or am I accommodating you because you did the idea of not wearing a mask or coming back? I like that, to marry accommodating with remote. Thank you for that, Allan. I think that will help. I know it'll help me when I coach folks. Of course, I'm sending them to you when it comes to this kind of situation. But in reality, what is it that the viewers can take away? Is it am I accommodating a real situation here? Or is it just a preference?
Right.
Yeah.
Right. Yeah.
Whoa, wow. Okay, so love remote and the accommodation. And I know you've talked about accommodating in other ways. There's a new medical accommodation going on out there. Tell us about that.
Yes, and so this is a big development for employers. And so Massachusetts has passed a new law that's now in place, the Paid Family Medical Leave Law. And this applies to all Massachusetts employers. And so there's some confusion about what types of leave laws apply to different employers, et cetera. And frankly, it is confusing. But now with this new statute, it's a new landscape that employers are going to have to understand and navigate. And so there was a mix of federal laws, private insurance, and then some state laws already in place, right? There's the federal law, most of your viewers probably have heard of at least, the Family Medical Leave Act, FMLA. Right? But that only applies to private employers with 50 or more employees, right? And it provided job protection, but no pay. And then for pay, there were also private insurance, short-term disability, long-term disability available. But now this new Massachusetts law, this provides protected leave and it provides pay.
Protected leave. What does that mean? So tell us about what this covers. Protected leave. Plus the word, the P word gets us a little nervous. And because if we're really small, under 50, we're not even in tune with the other law as it was. So we can't even do an association, Allan.
Sure, absolutely.
Help.
So yeah, a lot of small business owners, the FMLA was just sort of off their radar, right? Because they had under 50 employees. But now this new law is going to apply to them and probably most of their employees, right? And so this is a big change for small business owners in particular. And so by protected leave, that generally means that you have to allow the employee to take the leave. You can't terminate their employment generally. And so that protects their job while they're on the leave. That's what we mean by protected leave.
Oh, okay.
In terms of pay, I understand that there could be some anxiety about that from an employer's perspective, but we've actually been paying into a trust fund in Massachusetts for a couple of years now. And so there's a small amount of everybody's paycheck going into this. And so that fund is what is going to pay the employees during the leave.
Okay. All right. So, there's two questions. How does this law apply to Sheila? Because I don't think she's got 50. So this is new for Sheila. And I'm sure there's some viewers out there saying, oh my God, I'm just like Sheila, for sure. And because I have clients that are just like Sheila, but not the employees of Stealing. And the other part is, we got to lay off John. God help us. What happens if John is on medical leave and she discovers this while John's on medical leave? I know I piled up the questions. Can you?
Yeah, no, that's fine. Absolutely. So number one, Sheila has to know that the law probably applies to her, right? So she's going to have to know about it. And one of the rules in this law is she can't take adverse action against an employee while they're on leave or within 6 months after the leave ends. And so that's significant. If she does take those actions, termination, say, is the classic adverse action, then there's going to be a presumption that she's retaliated against John in this instance. Let's say he just got back from leave when this circumstances came to light regarding him stealing funds. And so she's going to have this presumption in place that she's retaliated against him. And so she's going to have to be very careful about how she does that if she moves forward. It is a rebuttable presumption. That means that if she has clear and convincing evidence under the law, whatever that means, then she can rebut it. And so what I would suggest would be helpful to rebut it would be if you have good documentation. Does she have good records showing that this person was taking funds from the company, basically? Did John admit it? And did she document that in some way? I believe he did. And so she probably wants to document that. So she has a good record of what happened. She wants to be consistent about how she approaches these types of situations. And so was there someone else that engaged in similar conduct, say? And so she's going to want to make sure that she treats John in a similar way. And one other aspect here is the employers should be aware of on the mass law is that they can't change employee benefits while the person's on leave. They have to maintain those benefits and keep them the same. Otherwise, that could get them in trouble as well. So Sheila does have wants to be careful here, make sure she's acting consistently and documenting things in order to get herself avoid falling into some traps.
Oh my. Well, I know this might be a one-off, and I know we've got about 2 more minutes and we still have I guess it's non-compete and non-solicitation. Can you wrap this up in about 2 minutes for us, Allan? But give us your recommendations about this law about compete and non-compete. I know you can just give us a recommendation and help us out here, trim that.
Yeah, no, I'll do my best.
Okay.
So there is a new non-compete law. It's been in place since 2018, and it only applies to non-compete agreements, which are different than non-solicitation agreements. That's an important distinction. Non-compete means you can't compete at all with your former employer, and non-solicit means you may be able to compete, but you just can't go after clients of the former employer, right? And so a non-solicit is a more limited restriction. And so courts are a little bit more inclined to enforce non-solicits than non-competes. Courts generally don't like non-competes. But this new law also imposed a bunch of requirements on non-competes. It's only limited to a year. It can't apply to hourly employees. You got to give it within a certain time period. You have to tell them to consult with counsel. You have to pay them during the non-compete period. So there's all this stuff and more. And so employers really should be considering strongly, do you really want the non-compete? Does it make sense for what you're trying to protect in your business? Or is the non-solicit, which may be easier to enforce, going to provide you sufficient protection? So yeah, I strongly recommend that employers really give strong consideration to whether or not they need the non-compete at all to protect their clients, which is really probably the heart of most small businesses.
Isn't that interesting? Because we all say non-compete because we think of competition. But from now on, I'm going to be talking about you've taught me something today, at least, not just one thing, Allan, and I'm sure you've taught a lot of our viewers a lot, which means, oh my goodness, I mean, this was too much fun. And of course, we're all business owners, and so we're very aware, and we love that we have these wonderful assets called human employees, but yet we have to treat them the right way. So Allan, I need to wrap up, but I do want to say thank you so much for being here, taking time from your business and your clients to be with the people out here. Thank you so much and really appreciate it.
Yeah, thanks so much for having me. This has been fun.
This has been fun. So viewers, let me wrap up. If you have even gotten one morsel of information from Allan that you learned today and that you can use tomorrow, which is a good thing. Trust me, you're like, oh my goodness, I'm stuck. Please keep in mind that his info is at the end of this program and that there will be another topic in September. So stay tuned, look at the WACA TV website, find out when we're going to air, or it will be on the website, and we'll have someone with business practices for you then too. So until then, have a great month and please take care.